People versus James Lee Crowley. Can you raise your right hand? Detective, do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Can you state your name for the record?
Detective Philip Collop.
Have you read the type complaint that was filed with the court?
I did.
Are the facts stated in the complaint true to the best of your knowledge and belief?
They are. This is a supplemental from a prior misdemeanor that was for court today. That's getting amended to a felony.
Okay. Can you, are the facts stated in this complaint true to the best of your knowledge and belief?
Yes.
Can you state the facts that support the issuance of the arrest warrant?
On 2/3 of this year, at approximately 1:30 in the morning, Taylor officers were dispatched to 14603 Harold Avenue for a domestic assault. Dispatch advised that the defendant, James Crowley, was at the address destroying the home with a bat after becoming irate. Upon arrival, officers made contact with victim Ashby outside. Ashby stated that her boyfriend, James Crowley, was in the home, threatening to burn it down with everyone inside. Ashby stated Crowley was destroying the home with a bat and preventing her from calling 911 by hitting the phone out of her hands. Ashby stated that Crowley cornered her and prevented her from leaving the southeast bedroom of the home and continued to use the bat to destroy objects in the home. Ashby feared that Crowley would use the bat to hit her due to his erratic behavior and aggressive nature. Ashby stated that Crowley continued to make threats while holding the bat and used the bat as a means to prevent her from freely moving about the residence and preventing her from leaving through intimidation. Crowley was aggressive with Ashby and not allowing her to leave for approximately a half hour. Crowley went to the bathroom and Ashby was able to grab her keys and the cell phone and fled to call 911.
Okay. Did you sign the complaint before you sent it over to the court?
Yes.
All right, let the record reflect. I find probable cause with the accused committed the alleged offense, and I'll therefore issue the warrant.
Thank you.
Mr. Crowley,
Yes, Your Honor.
you've been charged with the felony offense. Listen, there's an allegation that a property located at 14603 Harold Street in the city of Taylor, Michigan, 48180 on the date of February 3rd of 2025. The complaining witness says that on that date and at that location described, the defendant, that's you, contrary to law, did count 1, assault with a dangerous weapon, felonious assault. Did make an assault upon Jennifer Marie Ashby with a dangerous weapon, to wit a bat, but without intending to commit the crime of murder or to inflict great bodily harm less than murder, contrary to MCL 750.82. This is a felony, punishable by up to 4 years in prison and or a fine of $2,000. DNA is to be taken upon arrest, and a consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. You're also charged with count 2, domestic violence. The state of Michigan alleges that you did make an assault or an assault and battery upon Jennifer Marie Ashby, an individual with whom you had a dating relationship, contrary to MCL 750.81 parent 2. This is a misdemeanor, punishable by up to 93 days in jail and or a fine of $500. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. Sir, you have a right to remain silent. Anything you say orally or in writing can and will be used against you in a court of law. You have a right to an attorney, and you have a right to have that attorney present during any future questioning and any future court hearings. In the event you can't afford an attorney, one will be appointed to represent you. You have 2 dates within the next 21 days. The first is your probable cause conference, which is set to occur on the small one. I don't have a calendar.
Your Honor, may I speak?
Not yet. Listen,
Okay.
you have 2 court dates within the next 21 days. The first is your probable cause conference, and that is set to occur on May 5th of 2025. And you can appear at that hearing via Zoom. Following that, you will have a preliminary exam. At the preliminary exam, the prosecutor must show that a crime was committed and probable cause exists to charge you with that crime. And that will occur on May 12th, 2025, in person at the 23rd District Court.
May
At
12th.
at 10:30 a.m. And your PCC is, your first hearing will be next Monday, May 5th at 10:30 a.m. And then the exam will be in person on May 12th. So, Mr. Crowley, the case
Your-
against you has been amended to add a felony. You have a right to an attorney. And if you can't
Yeah.
afford one, we'd appoint one. Do you want an attorney?
Yeah, I think it's best now that I get an attorney for this one.
It is the best. Okay. We will appoint counsel for you. We have to fill out some paperwork, and your attorney will be in contact with you. And if not, they will be here on May 5th and you'll be able to meet with them then. Normally they call you ahead of time. And I'm just taking the bond on the misdemeanor case, and I don't have that file in front of me, whatever the bond was on the misdemeanor. Never mind, I have it. $700 cash bond that you filed will follow you over on this case. You have the same. You have the same bond conditions, okay? You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. You're to have no contact with Jennifer Marie Ashby.
Your Honor, and what about when people have contact with me?
Wait 1 second, 1 second. Mr. Ashby, I'm sorry, Mr. Crowley, let me get through the things I have to say to you, because I need you to listen, okay?
Yes, ma'am.
You can't call her, you can't write her, you can't email her, you can't send her anything. You can't go to where she lives, works, or goes to school. You cannot have any contact of any kind. You can't have someone else do any of these things for you except for your attorney. You can't send text messages, instant messages, emails, tweets, or any other form of communication or contact her through any other social media site. If you have her programmed in your phone, delete her. If you send her a blank empty message, I will consider it contact, since I'm instructing you not to do that. If the communication comes from you, Mr. Crowley, if you don't listen, you know what? Like, some people are just waiting for their turn to talk. And Mr. Crowley, I have to say this to you, and I need you to stop thinking about what you want to say back to me and start listening and processing the information I'm giving you. Because if you don't process this information and hear me, and then you violate, you're going to jail. So this is important, okay? I'm trying to make sure you understand what no contact is, so that you understand that if there's contact and I put you in jail, you can't go, well, I didn't understand that, or I didn't hear that. Listen, okay? If you have her programmed in your phone, block her. You can't send her empty messages or blank messages. I will consider it contact. It will be a violation. It will not be a defense that you accidentally contacted her. If you go to a store, restaurant, or a party, for example, and she is there, you must leave immediately. If she contacts you, do not reply. This is an order of the court. The person named as the victim in this case cannot change, alter, or amend the order in any way. She can't change it, only a judge can. If she were to invite you over or ask you to meet her somewhere or contact you for any reason, you cannot violate the court's no contact order. And if you do, you will go to jail. If the order needs to be changed in the future, I will hold a hearing on it when both sides are present. Do you understand all of that, Mr. Crowley?
Yes, Your Honor. And I just want to reassure you and the court and the people, I have not contacted her. I'll give my telephone up to the state for tech to investigate my phone, everything. I have not. I don't want any trouble. I just want to resolve this as quickly as possible. This
Good.
is
All right.
ruining my life.
All right, Mr. Crowley, I have to tell you a few more things, okay? And listen, Mr. Crowley, you've been charged with a felony.
Yeah.
And I told you at the beginning, you have a right to remain silent. You need to talk to your attorney before you start making all these statements, because you might say something that incriminates you.
Your Honor,
Okay?
the truth
no,
can't
listen.
incriminate me.
Mr. Crowley, listen to me. I'm not fighting with you. I'm trying to help you understand your rights and understand what I expect from you. You cannot possess or have access to firearms. You cannot consume alcohol or illegal drugs. You can be subject to testing on demand at your expense. And those are your bond conditions for now, Mr. Crowley. We have 2 court dates coming up, May 5th and May 12th, both at 10:30 a.m., May 12th here to be in person, okay?
Yes, Your Honor.
And that other case, I assume, is going to be dismissed. And we'll just convert your bond from that case to this case, so you shouldn't have to post any more money.
Thank you, Your Honor. And so I'm being charged with felonious assault and domestic violence?
Correct.
Thank you.
All right, now, Miss Ashby, you also received those dates, May 5th and May 12th. May 5th,
Yeah.
you can appear via Zoom. May 12th, you must appear in person. And Miss Dennis, would you like to speak
Yes.
with Miss Ashby in a breakout room?
Yes,
All right,
Your-
we'll get 2 of you in a breakout room. And then Mr. Crowley, you
Your
should be
Honor.
all set for today. And
Okay.
you will, I'm going to, as soon as the prosecutor, unless you want to wait, the prosecutor's going to make a motion likely to dismiss this other case, and I'm going to grant that. So that's what's happening on that. And we'll see you back on May 5th.
Thank you, Your Honor.
Your Honor, I don't need to be present for that dismissal, I suppose.
All right, well, that's what I'm doing, and that's what I'm assuming they're doing. So we should be okay.
I mean, should I wait, or I don't really need to? It's the court. I don't really, it's all good. I don't need to be here for this.
I told you what I'm doing. What I'm doing is what I'm
Yeah,
doing. So it's
I
probably
agree.
good. It's on record.
Cool. Thank you very much, Your Honor.
Okay, yeah.
Am I dismissed now?
Yep.
All right. Have a good day.
Thank you, Your Honor.
Wait, we're gonna join.
Okay.
All right, we're all set. And